and they're in, they can't get out, and they say, oh, hang on a minute, I actually can't deliver it like that, or maybe like that, and then they're in trouble. So this is as important as the actual bidding process or awarding process, the terms and conditions. The public contract itself, the templates, the terms and conditions, are not subject to EU award rules. Any country is free to draft them and say, this is how we do it, and any bidder has to accept that. And so just national law applies, whether it's legal or not. Usually it's quite legal, because it's the government who passes those templates. And usually these templates and terms and conditions are not negotiable. Now, from practice, I know to some extent, depending on the needs and requirements, they can be, or parts can be negotiated. But formally, it always says, and it's part of the request for proposal, it says, this is not negotiable, accept it. Example of terms in the UK. So in the UK, it's centralized a lot by the UK Crown Commercial Service these days. And for supplies that are above the threshold that we just talked about, there is a goods and services framework agreement, and there's a goods services contract. That, of course, doesn't cover all the possible agreements, but what the UK Crown Commercial Service says that this is a starting point. This kind of gives you a flavor what we think is right and what we want to see. So often the governments start with one of these agreements, and then they are very freely and flexible depending on the authority that buys in changing and amending this. For below threshold supplies, there's the short form terms and conditions for goods and services, which you can even download as a Word document. So that is that tells you already that it's fairly flexible, in which you can look at and then negotiate with the authorities. Another example, Germany. It's a bit more strict. There, the government has drafted particular terms which are applied to public procurement. They're quite general. They're not specific on particular products, which is why then industry lobbying bodies have negotiated with governments and approved by the Antitrust Office special terms and conditions for certain industries. So, for example, IT industry in Germany has negotiated over years with the government, and there are now sets of terms which are called the EVBIT, and you have EVBITs for supply of hardware, software, licensing, system integration, etc. And these are the ones that apply, and they are not negotiable. And otherwise in Germany, any authority can create their own terms and conditions, and that's what they actually do. And it's quite adventurous what you sometimes read there, and well, you have to some extent you have to accept it, but to some extent, if it doesn't make sense, you have to speak up and say, look, this may be right, those terms and conditions for buying pencils, but I'm delivering an IT system. This, your terms just don't work with this. And it sometimes needs quite a bit of convincing to do, but in your own interest, you have to do it.